Today we're going to be talking about California's SB2. If you don't live in California, don't think you're out of the woods. But more importantly, the way that California wants to completely eliminate anyone's ability to get a CCW in the first place. All right, let's talk a little bit about what SB2 is, and if you don't live in California, why this is so critically important, even for you. One of the previous videos that I did a while back, I was talking about what the state would be doing, and I use the state in sort of like an overarching term, but what the state would be doing in response to Bruin. The state does not like the idea that they are being mandated to follow the Constitution. In fact, from a philosophical standpoint, there's always been this tension of, the state, and by the way, our framers envisioned this, the state looking to, expand its power base and being constrained by the Constitution, right? It's a natural tension point. In this particular context, the state gets told by the Supreme Court that, hey, you've got to give CCW permits to people that want them. And now the state is trying to figure out how to go around doing it. Well, in California and in New Jersey, immediately following Bruin, there was a legislative attempt to effectively prohibit people from getting permits. In New Jersey, it was called Chapter 131. We did a video on that a while back. In California, there was a piece of legislation called SB 918. That failed, interestingly enough. It failed by one vote. But then it got resurrected again, now called SB2. And SB2 is actually divided into three separate parts. The first part of SB2 is this long preamble where the legislature essentially states that guns are bad and people with guns are bad and we don't like guns because they're bad, and that's pretty much it. The second part of SB2 deals with training. Now, that's going to be very interesting because that's where the state is now making their argument. We'll talk about that in just a second. The last part of SB2 is the one that most people in California and nationwide, frankly, get kind of spun up on. It's the same thing we saw in Chapter 131 in New Jersey, essentially saying, okay, we acknowledge that we have to give these CCW permits, fair enough, but we are going to make all of our state a sensitive location. So yes, you can get a permit, but it's going to be illegal for you to carry a gun pretty much anywhere because we are going to essentially state that every single place that you could potentially go is in fact a sensitive location, and it would be illegal for you to bring a firearm there, even if you have a concealed weapons permit. Understandably, most people that currently have concealed weapons permits are very, very focused on this part 3, okay? And there's a couple of legal challenges to this aspect of SB2. The big one is called Reno May v. Bonta. This is a court case challenging the sensitive locations aspect of SB2. They filed a preliminary injunction on that case to prevent this law from going into effect on January 1. Oral arguments are actually set for December 20th, so they're coming up here relatively quickly. The judge that is going to be ruling on that case and also ruling on the preliminary injunction is actually a very, very good judge, Judge Carney Carmack. He issued a preliminary injunction against the California roster of handguns. Already has shown that he knows how to do a Bruin analysis. So we're very comfortable in the fact that we have Judge Carmack working on this particular case. Now, that being said, a lot of the different civil rights groups that are fighting for us, for our Second Amendment rights, when they looked at SB2, they purposefully decided not to challenge that second part where they talk about the new training requirements in order to get a CCW. Because, to be quite candid, it looks bad, right? I mean, to people who are not in the Second Amendment community, Somebody's sitting there saying, I gotta go buy a gun and then I'm gonna carry a gun because I don't need no stinking training. Hell, I've been carrying guns and playing with guns longer than you've been alive, son. I mean, that kind of mentality, that stereotype is exactly what turns, not people, within the Second Amendment community, but people that are somewhat ambiguous about gun rights, it turns them off, all right? So these different civil rights organizations said, well, let's just focus on the sensitive location doctrine. Challenge that. So one of the requirements in California prior to SB2 is that if you wanted to get a concealed weapons permit, you had to undergo training. You had to go to a licensed training provider, and it's the individual issuing agency, the local sheriff typically, that will create a licensed training provider. They will go to the issuing agencies, show a copy of their curriculum, show their instructor credentials, and then the issuing agency will say yay or nay. We will either endorse you as a trainer or no, we don't want you to be a trainer. Okay, guys, I'm going to pause this video for just a second. USCCA, which is the ones doing this video, they're doing a giveaway. And it's very, very cool, but it also ends very soon. So you're going to want to go to the links below in the description on this video, click on it, and you're going to want to participate. All right, let's get back to the video. The California legislature up to this point has mandated that if you are an initial applicant for a CCW, you have to take a class that is no longer than 16 hours. If you are a renewal applicant, you have to take a class, and you have to get renewed every 2 years. You have to take a class that is no less than 4 hours. The new requirement with SB2 states that you have to take a class as an initial applicant that is no less than 16 hours. So they create a 16-hour minimum. And if you're a renewal, it has to be a minimum of 8 hours. Regardless of whether you are an initial applicant or a renewal applicant, one of those hours must be devoted to mental health. I'm going to sidebar for a second because this is kind of amusing. In the mental health requirement, it does not mandate that the person actually teaching the section be a mental health care provider. Anyone can do it. Also, interestingly enough, there's nothing in the statute that says that mental health and firearms needs to have a nexus, right? I mean, just mental health, whatever vague concept that means. So as a CCW training provider, if I wanted to spend an hour talking about the emotional benefits of being involved in polyamorous relationships, that would be totally acceptable according to the California legislature, which frankly may be exactly the kind of mentality that some of the legislators have. So I think that mental health component is frankly arbitrary and capricious and frankly subject to a legal challenge in and of itself. Now, having said that, on December 8th, the California Department of Justice showed their hand. Remember I said that the training requirements had not been challenged by the different civil rights organizations that are challenging SB2. So the Department of Justice issued emergency orders on December 8th stating that if someone wants to be a CCW training provider, they now have to petition directly to the California Department of Justice because they are going to create a brand new type of Department of Justice trainer called the CCW trainer. This status has never existed before. There are DOJ instructors, okay? These are basically, if you are an NRA instructor, you can fill out a form and you can become a DOJ instructor. And it's been like that for decades, okay? Well, now they're going to create this new type called the CCW trainer instructor. And the only way to become a CCW training instructor is, number one, you have to be a post-certified instructor. that means that you effectively came from law enforcement and you are a post-certified firearms instructor. Number two, you have that another pathway in is that you are a BSIS certified firearms instructor. BSIS is the state organization that up until recently regulated both security guards as well as barber shops. So you can see how they have a fundamental knowledge on CCW instruction. The last one is that you come from an state accredited training school. That one's interesting because there is no such thing as a California state accredited firearms training school. There are, however, something called comparable training entities. Now, this gets really nuanced and complex, and I'm not going to go into all the details, but effectively, if you are a current California DOJ instructor, you can petition to become a comparable training entity, which then would be the functional equivalent of being a state accredited school. I know, it's bizarre, but that's exactly the way this thing is set up. Once you have figured out which pathway you want to take, you then need to fill out an application, which incidentally does not exist yet, but you need to fill out an application to become a DOJ instructor. Use DOJ CCW instructor. You would then send this up to California DOJ along with a proof that you have adequately completed the state mandated CCW instructor training shoot. Okay, you actually have to go to one of those accredited schools we mentioned and fire off, and I don't even remember the exact number, but fire off a certain number of rounds with a certain course of fire and achieve a certain score. What's also interesting is that if you are a school, right, and you are applying to become a CCW trainer, there's nothing that says you cannot self-certify that you actually passed the test. So again, becomes really weird. But here's the kicker. All this needs to be done by January 1. Okay, you're basically given 2 weeks. And oh yeah, the infrastructure doesn't exist to process these applications or anything else. And you know what? After January 1, since we couldn't mint you as a CCW trainer, I guess you can't do CCW training. And if you can't do CCW training, then applicants, both for an initial as well as a renewal, will not be able to satisfy that statutory requirement that they've got their training and then be able to get their CCWs. So it is a backdoor way of preventing people from getting permits in the first place. Oh yes, we acknowledge we have to give these permits. It's not our fault that no one within the state has the capacity to provide the training requirement in order for somebody to actually get a permit. There will be lawsuits filed against this. The question remains as to whether or not the existing lawsuits, like the one I mentioned earlier on May v. Bonta, whether that's going to have an amended complaint or whether or not we're going to be filing a brand new lawsuit on this, or several lawsuits, frankly. I do suspect that this will be enjoined, okay? Because it's untenable for it to go any other way. It absolutely will destroy someone's ability to be able to exercise a specifically enumerated right. Now, if you don't live in California, don't think you're out of the woods, okay? A number of other states are looking exactly at what California is doing and trying to see how they can incorporate that into their own jurisdictions. So this needs to be killed off here in California. Otherwise, like a cancer, it can spread to other areas of the union. So am I concerned about it? Yes, I'm definitely concerned about it, because anytime I can see someone's civil rights being violated, it infuriates me. I mean, that's why I got into this business to begin with. Am I concerned that it might actually go into effect and prevent people? Not terribly, but I'm watching. So, and stay tuned to this channel. Obviously, there'll be more information as things come to develop. This is very, very fluid and happening very, very fast. As always, if you need to email me directly, please do so at steven@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.